Good afternoon. Welcome to the Heritage Foundation and our Douglas and Sarah Allison Auditorium. We, of course, welcome those who join us on our heritage.org website on all of these occasions. For our guests here in-house, we always remind everyone for that courtesy check to see that our mobile devices have been silenced or turned off. For those watching online, you're welcome to send questions or comments at any time, simply emailing speaker@heritage.org. And of course, we will post today's program on the Heritage homepage for everyone's future reference. I note again, this is the second of our Preserve the Constitution series lectures that will continue throughout the fall. Hosting our event today is Elizabeth Slattery, Legal Fellow and Appellate Advocacy Program Manager in our Meese Center for Legal and Judicial Studies. Ms. Slattery focuses on the Supreme Court, separation of powers, judicial nominations, and a variety of constitutional issues. She also manages Heritage's moot court sessions, which prepares litigators for oral argument in cases before the court. Her work as an expert on constitutional issues includes testifying before the U.S. House, and her commentaries have appeared in many major news outlets. Please join me in welcoming Elizabeth Slattery. Elizabeth?
Thank you, John. The Supreme Court's 2017 term begins in 2 weeks, and the justices have already agreed to hear a number of important cases. This term, they will tackle issues such as the balance of power between the state and federal governments, how technology poses new challenges under the Fourth Amendment, the scope of President Trump's travel order, whether the Alien Tort Statute applies to corporations, political gerrymandering, and the long-brewing showdown between religious freedom and gay rights over wedding industry services. We'll also see how the newest Justice Neil Gorsuch measures up in his first full year on the court. The upcoming term promises to be one for the history books. To discuss these cases, we're fortunate to have with us today two of the top Supreme Court advocates around. In order to get to our panelists, I'll keep their introductions very brief. Pratik Shah is a partner at Aiken Gump, where he is the co-head of the Supreme Court and Appellate Practice Group. He's argued 13 cases before the Supreme Court, in addition to numerous cases in other federal and state appellate courts. Pratik served for 5 years as an assistant to the Solicitor General. Before entering government, he worked at WilmerHale and taught at the University of Alabama School of Law. Pratik clerked for Judge William Fletcher on the U.S. Court of Appeals for the Ninth Circuit and Justice Stephen Breyer on the Supreme Court. He's a graduate of Princeton University and the University of California, Berkeley School of Law. Paul Clement is a partner at Kirkland & Ellis, and he served as the 43rd Solicitor General of the United States. He's argued more than 85 cases before the Supreme Court. In fact, Paul has argued more cases at the court since 2000 than any lawyer in or out of government. Paul served as the chief counsel of the U.S. Senate Subcommittee on the Constitution, Federalism, and Property Rights, as well as clerking for Judge Lawrence Silberman of the U.S. Court of Appeals for the D.C. Circuit and Justice Antonin Scalia at the Supreme Court. Paul received his bachelor's degree from the Georgetown University School of Foreign Service and his JD from Harvard Law School. So with that, Paul, can you kick things off and tell us a little bit about the sports betting case out of New Jersey?
Sure. So this is a case that will likely be heard in the court's December sitting. They haven't scheduled the specific date for argument, but that seems when it's likely to be heard. This is a kind of long simmering dispute that's been going on between the state of New Jersey and the sports leagues. It started a couple of years ago when the state decided that it wanted to authorize sports gambling in the casinos in Atlantic City and a couple of racetracks. If you sort of think about the arc of the sort of gaming industry in New Jersey, it got started at a point where there was very little sort of, casino-style gaming anywhere kind of, east of Las Vegas. And that was, that's a pretty good gig if you can get it. But as time moves on, and especially with the Indian Gaming Regulatory Act and the like, and you start having lots and lots of other alternatives for gaming, sort of east rather of Las Vegas, times get harder. And so the state, I think, understandably wanted to sort of put a sort of shot in the arm of the casino industry and wanted to authorize sports gambling at the casinos there and at racetracks. Only one problem. There's a federal statute that says you can't do that, and that's called the PASPA, the Professional and Amateur Sports Act and Protection Act. And, you may sort of, not spent a lot of time thinking about it, but if you ever wondered why is there gambling lots of places but a sports book only in Las Vegas, it's because of this federal statute. And it provides in most relevant part that it shall be unlawful for a government entity to sponsor, operate, advertise, promote, license, or authorize by law or compact a lottery, sweepstakes, or other betting, gambling, or wagering scheme based directly or indirectly on the outcome of one or more competitive games in which amateur or professional athletes participate. So that statute has been on the books since 1992. New Jersey passed a state law authorizing gambling at its casinos, knowing full well that this law was on the books. I believe Governor Christie at the time literally said, if somebody wants to sue, bring it on. The sports leagues obliged and brought an action which is actually authorized by the statute to enjoin this state-authorized sports gambling. And the leagues prevailed in the district court in the Third Circuit. New Jersey filed a cert petition, and that cert petition was denied. But undeterred, being told that they couldn't sort of directly authorize sports gambling at the casinos, New Jersey decided that it was going to instead come back with a repeal of its sports gambling laws. But it was a repeal with a kind of a twist, which is the statewide prohibition on sports gambling was repealed only at casinos and horse tracks, only for individuals over 21, and only if the gaming involved non-New Jersey college teams. So with that very unusual partial repeal, the state came back into court and said, look, we don't violate PASPA this time. We're not authorizing it. We're simply repealing our pre-existing prohibition. The district court was not overly impressed with that argument and said this is a de facto authorization. The Third Circuit affirmed. Then the Third Circuit did something a little unusual, which is without an obvious split in authority, they granted en banc review. But nonetheless, after considering the case en banc, they came out the same way and upheld the constitutionality of PASPA by something like a 9-3 vote. The case, a cert petition was filed at a point that the justices had just 8 justices. The court called for the views of the Solicitor General, which was a little unusual since the Solicitor General had already authorized the government to defend the constitutionality of the law in the lower courts. But it did have the virtue of buying some time. And so by the time that the court considered the case after getting a brief from the Solicitor General reiterating that the United States still thinks an act of Congress is constitutional, the court then granted certiorari in the case. The issue in the case is really one of federalism and particularly a doctrine called the anti-commandeering doctrine. Those students of federalism will know that the anti-commandeering doctrine is really based on 2 Supreme Court cases, New York against the United States and the Prince case involving the Brady Firearms Act. Those cases in various ways basically said that the federal government cannot commandeer state legislatures or state officials and force them essentially to administer federal law. Whether or not that doctrine really applies to PASPA is, the nub of the issue before the Supreme Court. I represent the sports leagues, so I don't want to get too deep into sort of the merits of this, lest everything I say be discounted. Anyways, what I'll say is really this: I think it's if you want to understand sort of this case, I think it's worth rereading Justice Scalia's opinion for the court in the Prince case. Because Justice Scalia was very aware that it's a fine line between commandeering, which is forbidden, and preemption, which is kind of ordinary, happens every day in lots of federal statutes. And so he wrote the Prince decision relatively narrowly and with a conscious eye towards not sort of overturning, dozens of cases that said that of course the federal government can tell the states how to legislate if it preempts contrary state law. So I think when the court wrestles with this case in the December sitting, it's really going to be focused a lot on, that particular line of, is this a preemption statute? Does it cross a line and do something more? And part and parcel of that will be, what states are really open to, what options are open to the state. The state sort of wants to present this as if they have to keep their existing prohibition on the books. On behalf of the leagues and the United States, we both argue, actually, they don't. If they want to sort of go the decriminalization route and not have any prohibitions on sports gambling, they're free to do that. So that's part of the debate. But I think the more interesting debate, frankly, is the broader one about what's the line between preemption and commandeering. And the last thing I'll say, which probably does show my, sort of the fact that I've been working on this case through the lens of my clients a lot. But it is a funny sort of idea of federalism that, that it's okay, which New Jersey has to concede, for the federal government to go in and regulate all the details of sports gambling. But if they look out at a point where a couple of states are starting to legalize sports gambling, but the vast majority of states continue to prohibit it with their own, state-chosen means of prohibiting it and their own penalties, if they sort of leave those in place and say, we just don't want any new states authorizing gambling, that poses a distinct problem from a federalism perspective when it's conceded that they could go in and regulate the whole thing directly. Now, there are answers to that, but I think that's another kind of interesting aspect of the case.
Pratik, why don't you tell us about the travel order case?
Sure. The travel ban case is going to be argued in October, so it's coming up very soon. And unless you've been living under a rock for the last 6 months or so, you know the basic facts about the travel ban case. It started, of course, in January with the executive order from President Trump banning the entry of folks from, at the time, 7 Muslim-majority nations. That sparked chaos at the airports, a flood of lawsuits, public outcry. That executive order was then revised in March. It eliminated Iraq from the list of countries. It made some other changes. But again, that travel ban did spark a flurry of lawsuits. It does 2 main things, among other things, is it provides a 90-day suspension of entry of any visa seekers from those 6 Muslim-majority nations, and it suspends refugee applicants for 120 days. Now, among these lawsuits that were filed challenging the travel ban on a host of statutory and constitutional grounds were a challenge brought by the state of Hawaii. That ended up in the Ninth Circuit, included relatives of targeted individuals, and then a separate challenge that ended up in the Fourth Circuit brought by refugee organizations and others. The Fourth and Ninth Circuits both affirmed preliminary injunctions that the district courts in those various circuits had entered against the travel ban. The Fourth and Ninth Circuit's decisions were largely across the board against the government. They did differ in scope in some respects, and then they differed on the theories in which they were affirming the preliminary injunctions. There was both a constitutional theory as well as a statutory theory. Now, the 2 main camps of arguments, the constitutional argument is an establishment clause argument, essentially arguing that the travel ban is a pretext for discrimination against Muslims, and the challengers invoke several pieces of evidence to support their establishment clause theory, their theory of pretext. And they use the campaign statements that then candidate Trump made about banning Muslims from entering the United States, about worrying about terrorist acts by Muslims, and then post-campaign statements that were made around the time that the executive orders were issued, statements like, quote, "We all know what that means," when he removed the language that took out the special protection for Christians, but left in the ban for folks coming from the Muslim majority nations. And so they essentially make their establishment clause violation based on this host of evidence, both campaign and post-campaign. The government argues in terms of the establishment clause theory that, look, this is an area at which the executive power is at its peak. We're talking about national security. And in that circumstance, you should defer to the president's determinations. And you shouldn't look behind the order. The order on its face is it's legitimate and bona fide, and that's the test from some Supreme Court cases in the visa issuance context. So the government says that because it's facially legitimate and bona fide, you don't look to the campaign statements, you don't look to these other statements. That's not the proper inquiry. You uphold it based on national security grounds and the immense power that the executive enjoys when you're talking both about immigration, who enters the country, and national security. That's one set of arguments. The other set of arguments are statutory arguments under the federal immigration laws. And there's two provisions under the INA that are implicated here. One that requires a finding that there's some detrimental impact on the United States before you suspend the class of entry, the entry of a class of aliens. So that's one provision that they say is violated. The other one deals with discrimination based on nationality. You can't discriminate based on nationality when it comes to issuance of immigrant visas. And so the challengers say both of those provisions were violated. The government responds that, look, when it comes to class-based distinctions like that, you have to defer to the executive once again when it comes to risk assessment. And again, this is not, the government says, this is not some ban on issuance of visas that the INA was worried about. This is really denying entry. That's different than denying an issuance of a visa. And by the way, these are not immigrant visas anyways, and the statute says immigrant visas. These are people seeking any sort of visa to come into the United States. The Supreme Court grants cert. No big surprise when you have an executive order implicating big questions like the ones that this order implicates. But I think more of a surprise to folks watching the case was that it did grant a partial stay of the injunction that the Fourth and Ninth Circuits had issued. So if you're staying the injunction, that means the travel ban can go into effect. And it went into effect in particular for those visa seekers and refugees who lacked a, quote, credible claim of a bona fide relationship with a person or entity in the United States. So that was the line that the Supreme Court drew in allowing the travel ban to go into effect in part. So partially staying the injunctions from the courts of appeals. It was a per curiam opinion that the Supreme Court issued in June that entered that partial stay. That means nobody signed it for the court, and so all 9 justices were on the order. But there was a partial dissent, not from, as I think some might have expected, from the more liberal justices on the court saying, why are you staying this order? But in fact, the dissent came from the right. It came from Justice Thomas, who was joined by Justice Alito and Justice Gorsuch, saying you should have stayed the injunctions in their entirety. That is, let the travel ban go into effect for everyone, and not just those who lack that relationship with someone in the United States. So that all happened in June. The travel ban has been in effect with respect to folks who lack that connection since June. And that raises another interesting issue. Because the travel ban went into effect and because it has a 90-day clock for the suspension of entry for visa seekers and a 120-day clock for refugee applicants, that means from middle to end of June to middle to end of September, before the oral argument will even happen, the travel ban will have expired with respect to the suspension provision for visa seekers. And then before a decision presumably is issued by the end of October, the 120-day clock will have expired with respect to those refugee applicants, which raises, as you may imagine, mootness concerns that I'll come back to in a second. But as of June, this is, I think it's fair to say, a pretty big win for the Trump administration to get injunctions by virtually every lower court and then affirmed by the 2 courts of appeals that had heard the case to get those essentially overturned in part or stayed in part while the Supreme Court hears it and allow the travel ban to go into effect. Now, after that Supreme Court order, there have been skirmishes in the lower courts and in the courts of appeals about the scope of that partial stay. You've probably read in the paper, do grandmothers count as someone having a close enough connection to someone in the United States? The court said yes. The lower courts have said yes, and so now grandmothers can apply. But the lower courts handed a victory to the challengers, saying all refugee applicants who have some assurance from an organization, they're in too. But the government went to the Supreme Court and said that reaches too far, and the Supreme Court agreed and put a stay to that order as well. And so you have these skirmishes that have been going back and forth, but the order itself, the travel ban itself as a whole, will be in front of this court and argued in October. And I think there's a real question on the merits. Usually when you get a stay like this, if you're the government and gotten a stay, you probably feel pretty good about your chances, because one of the elements of a stay is likelihood of success on the merits. But I think this is probably, if the court ever got to the merits, this may be closer than most cases in which you have a stay like this, and it may be headed to 5-4 sort of territory. But there is a good chance that we may never get to the merits. And that's for two reasons. One is the mootness issue that we talked about before, that in fact the travel ban will essentially have expired by then, and the whole purpose of the travel ban was to bring a suspension for a temporary period of time so that the government could improve its vetting procedures, get information from foreign governments. They will have had a chance to do that. Reports have been written. They've been provided to the executive. And so, and in fact, there is some language in the stay order in which the Supreme Court foreshadowed that there would perhaps be no longer any reason to hear the case after that period had expired. Now, of course, the Trump administration could make that mootness problem go away by renewing the travel ban, extending it. And there have been some, for those of you who are on Twitter or been following this thing, there have been some suggestions that perhaps that may happen, but I think it's hard to know, it's hard to predict with any administration, and perhaps this administration in particular. And so that's one big wild card that's at play in this case. And then the second question that would prevent them from getting to the merits is a standing issue. Do the plaintiffs that have brought the challenge here have standing to bring this challenge before the court, which is also somewhat of a thorny question that both sides have gone back and forth on, and I think it's hard to predict what the court will do with this. I don't think the court at all will be disappointed if this case goes away as moot, and they don't actually have to issue a decision on the merits. So I'll leave it at there with the caveat that this is a very fluid situation and a piece of litigation that is extremely hard to predict where it will end up.
So Paul, let's turn to the Wisconsin political gerrymandering case.
Sure. So, in this case, I filed an amicus brief on behalf of the Wisconsin legislature. So just by way of disclosure, I'll get that out. In terms of, the issue for the court, this is really the question of whether the court is going to find partisan gerrymandering claims justiciable, which is to say whether these claims can really go forward at all. The Supreme Court, about once every decade has an opportunity to decide whether it wants to adopt or can discern a justiciable test for partisan gerrymandering claims. To date, they have not been able to get 5 justices that think that there is a justiciable, manageable standard for these claims. Last time around, Justice Kennedy rather, famously said that, did not join the 4 other justices who found the claims non-justiciable. He wrote separately to say, well, I don't think I've heard yet a justiciable test, but I don't want to foreclose the possibility that there's a discernible justiciable test out there. And so he wrote separately on that. That certainly encouraged litigants to continue to find the holy grail of a justiciable test for partisan gerrymandering claims. A challenge was brought against the state of Wisconsin's map. Wisconsin happens to be my home state, so I know it well. It's also a relatively purple state in that, from time to time you have situations where the Democrats are in charge of one house, the Republicans the other, or maybe you have the Democrats in charge of both houses of the state house, but you have a Republican governor. And so, for most decennial cycles, it's been very, very hard for the government of Wisconsin to produce, the legislature to produce a map that the governor would sign. So for the last 2 or 3 cycles, you've had the phenomenon, which is not uncommon, unfortunately, where the legislative political branches are unable to produce a map, and so the elections actually proceed under a map that's imposed by the judiciary, who has to impose a map. You may ask, well, why don't they just leave the old map in place? Wouldn't that be the simplest thing? The problem is that doesn't work because of one person, one vote requirements, and every time there's a census, there's basically a requirement that the legislature draw a new map. This time, the Republicans were in charge of both houses of the State House, and also Governor Walker was in the governor's mansion, so they were able to produce a plan. That plan went with one very minor modification, survived some challenges on equal protection and voting rights grounds, and went into effect. The Republicans did very well under the new map, and in the view of the challengers, in fact, did too darn well. So they brought, after a couple of cycles where this map actually was in effect, the challengers brought a claim saying that this was an impermissible partisan gerrymander. And part of their evidence for that was that the Republicans, although they are, not a majority statewide, ended up with, a robust majorities in the State House, and increasing majorities over a couple of these cycles. So it was alleged that this was an impermissible partisan gerrymandering. When the challenge was first brought in the district court, the focus of what made this justiciable was a particular theory that focused on the so-called efficiency gap and wasted Democratic votes, such that if you had somebody in a highly Democratic district that won with 90% of the vote, 40% of the votes were deemed wasted. If you had a close but Republican-leaning district where the Republican won 55 to 45, the 45% of those Democratic votes were also deemed wasted. The three-judge court divided 2-1. And the 2-judge majority did not fully embrace the efficiency gap theory, but they did adapt sort of a variation of it and came up with a 3-pronged test that they felt made these claims justiciable, that turned on partisan intent, partisan effect, and lack of justification for drawing the partisan map. The Supreme Court took up that case, and it's now going to decide this case. It'll be argued the first week of the new term. The question in the case, as it's teed up, is really one of justiciability, whether these claims can go forward at all. The way that the case has been briefed, it's interesting because there's so much focus on whether there's an administrable test that what gets a little bit lost in the briefing is exactly what makes partisan redistricting unconstitutional in the first place. And in particular, there's both an equal protection theory floating around and a First Amendment theory floating around. And yet there's sort of one test that kind of covers both, which doesn't necessarily make a lot of sense, at least at first blush. And so I think the argument will be very interesting to watch. I think obviously a lot of the focus will be on Justice Kennedy, as it often is in these cases, but particularly because of the nature of the opinion that he wrote in Veith. It will be, I think all eyes will be on him as to whether he thinks, some part of what the challengers have offered here is finally what makes these claims justiciable. But I think kind of the more interesting aspect of the case is going to be the extent to which the justices look a little past the pure justiciability issue and start kind of probing both sides about, well, what really makes these particular map drawing exercises unconstitutional? And is it really an equal protection problem, or is it really more of a First Amendment problem, or I assume there'll probably be some justices that don't think it's any kind of problem at all. So I think it'll be very interesting to see that. There's also kind of a stalking horse for the merits in a standing question about whether you can bring these claims on a statewide basis as opposed to the racial redistricting context where you have to focus on the particular district that you're located in and have to allege that that particular district is unconstitutional. But that's really tied up with what is really the violation here. Is the violation being put into a particular district just because you're a Democrat? Or is the violation here something more that sounds more in the First Amendment, which might be more amenable to a statewide challenge? So it'll be an interesting case to watch.
Pratik, let's talk about the Masterpiece Cakeshop case.
Sounds good. Before I talk about that case, Paul's disclaimer reminded me that I was probably a bit amiss in not mentioning the fact that I filed an amicus brief yesterday in the travel ban case for the children of Fred Korematsu, Gordon Hirabashi, and Minoru Yin on Yasui on the side of the challengers, so you can probably discount everything I just said about the travel ban case. But Masterpiece Cakeshop raises an issue, and I'll be filing an amicus brief as a disclaimer on behalf of supporting the challengers in that case, supporting the state of Colorado in that case. Now, this case raises an issue that's really been looming since the Obergefell marriage equality case from a few terms ago. And that's, how do you accommodate the interests of those who sincerely object to gay marriage with the interests of public accommodation laws in preventing discrimination? Now, the facts of this case are as follows. The petitioner owns a cake shop, and he describes himself as a cake artist. And he bakes cakes for all sorts of occasions, birthdays, weddings, celebrations, graduations, and the like. Same-sex couple entered his cake shop and asked him, can you, we'd like to order a cake for our upcoming wedding. And he says, look, I'm happy to bake you a cake for a birthday or some other occasion, but I don't do cakes for gay weddings because I don't support same-sex marriage. End of conversation. And that's as far as it got. There was a complaint filed under the Colorado Public Accommodations Law. Colorado has a law that says those engaged in commercial enterprises can't discriminate based on race, gender, or sexual orientation. The commission found that this was discrimination based on sex orientation and therefore ordered the petitioner, the cake shop owner, that it should serve all its customers, including those who order cakes for same-sex weddings. This eventually percolated up to the Court of Appeals, which affirmed, and the cake artist sought cert. And after 14 relists at the Supreme Court, for those for inside baseball, so normally once a case is briefed up and you ask the Supreme Court to take the case, the Supreme Court schedules it for a conference and it makes an up or down vote. You either have 4 votes or you don't. Cert is granted or it's not. In certain occasions, the court will relist the case for another week or two if it's on the fence. This got relisted 14 times, probably not coincidentally. There were only 8 justices when it first appeared. And once Justice Gorsuch appeared, relisted a few more times, and then cert was granted. Now, there's 2 separate First Amendment theories at issue in this case. The first is a compelled speech theory. And basically the theory is that Colorado is compelling the cake artist to engage in speech. And the speech really has 2 aspects. One is the petitioner claims that his baking of the cake is an artistic expression, a form of artistic expression. And then the other piece of the speech claim is that baking a cake for a same-sex wedding has a speech component in that a same-sex ceremony has a message to send to the world, and that there is an affiliation that is made between the baker of the cake and the message in the marriage vows that comes forward. And so this is all part and parcel of an expressive message. That is the compelled speech part of the theory. That really implicates 2 Supreme Court cases. One is the Hurley case, in which the Supreme Court held that parade organizers didn't have to include a group, and that was a gay pride group that wanted to participate in that parade. And the Supreme Court said, look, the parade organizers don't believe in gay marriage, gay rights. They don't want to promote that message, so they don't have to include a group that would conflict with the message that they're trying to convey in this parade. So essentially giving speech protection to engage in speech and exclude speech that you think would conflict with your message. That's sort of the line of cases that petitioner is invoking. On the other side is the Rumsfeld v. Fair case, and that involved the dispute between universities and military recruiters. This is when universities wanted to bar military recruiters. Certain universities wanted to bar military recruiters from participating on their on-campus job fairs because they disagreed with some of the anti-gay employment policies that the military recruiters had at the time. And the Supreme Court said, yes, in fact, you can compel the universities to allow the military recruiters to appear. And the distinction the court drew between that and the Hurley case is that, look, nobody is going to associate the court reason. Nobody's going to associate the military recruiters' policy of not hiring gay people with the university's own beliefs. And so they said, look, there isn't that danger of a First Amendment harm, or at least it's incidental to the purpose there. So those are the two kind of key cases on the First Amendment compelled speech claim. There's a second First Amendment theory, and that's a free exercise theory. And the theory here is that this Colorado law burdens the exercise of the cake artist's religion. His beliefs against same-sex marriage derive from his religious beliefs, so he said it burdens my religion. Now, the problem for the free exercise claim is that the Supreme Court has held that generally applicable laws that target conduct but have some burden on religious rights are generally okay. So as long as the state is regulating conduct, even if it has a disproportionate effect on the exercise of someone's religious rights, that is not enough to strike down the law. In light of that precedent, petitioner here says, well, although this is a generally applicable law that targets conduct and so might otherwise be okay, it's not okay here because it's being enforced in a discriminatory fashion. And he points to evidence that, in fact, the state has allowed certain commercial purveyors not to engage in transactions that would involve speech that is against gay rights. And so he says, look, this is not being administered in an even-handed way. So it's a little bit more of a fact-specific sort of free exercise claim here. Now, there were 48 amicus briefs filed in support of petitioner. The respondent's brief hasn't been filed yet. Of those 48 amicus briefs, I think perhaps the most notable one is the one of the United States. So I think it's notable for a couple reasons. First, for the fact that the United States filed it all. This wasn't an obvious case necessarily for the United States to file. We have a state public accommodations law at issue. The government wasn't a party below. And of course, the government enforces its own anti-discrimination laws and therefore has some interests cutting the other way. But the government decided to file in support of the challenger, but when it filed, it only addresses the compelled speech theory. That is, it does not mention the free exercise theory in its brief. And that's pretty interesting as well when you read the government's brief. And I think perhaps it was a compromised position. There's been some reports about how there was disagreement within the federal government from some of the senior career attorneys as to whether to file. Who knows whether those reports are accurate or not. But it may be viewed as somewhat of a compromised position. And the other thing that the compelled speech theory allowed the government to do was to provide a limiting principle. And the government tries to provide a limiting principle in saying, look, not every vendor out there, not every person who has a business out there can claim an exemption from public accommodation laws. But this is a special case. This is someone who has an artistic expression. These are custom wedding cakes. And not only is this someone who has artistic expression, but it's in conjunction with a wedding ceremony that itself has special expressive value. And so when you combine those two circumstances, you have a small universe of potential objectors that have a real compelled speech claim and have a real First Amendment interest worth protecting. So in that bucket, the government puts cake artists like petitioner, custom wedding ring designers, wedding photographers, a pretty small, relatively small group of people. And the government tries to draw the line there and says, look, this wouldn't apply to like a hotel and renting rooms or someone providing a prefabricated good or service. And so that's the line that the government tries to walk. And I think the argument will be pretty illuminating in seeing how the government walks that line at oral argument, and quite frankly, how the court views this case, right? There's two competing line drawing objectives here. how to protect sincerely held religious objections to same-sex marriage. Can you force a cake artist to put a message on his cake that says something like, God loves same-sex marriage? That would seem to go pretty to the extreme and really conflict with maybe core First Amendment objectives. You don't have that record here, though, in this case, where the denial of service happened up front and not based upon the particular cake design or message that was being asked. And then on the other side, how do you avoid the parade of horribles from commercial actors coming in and requesting objections from public accommodation laws for all sorts of beliefs that it's hard for a court to parse the sincerity of? And so I think, again, as Paul said in his redistricting case, I think all eyes are going to be on Justice Kennedy. Does Justice Kennedy view this as an anti-discrimination case, which is how the state of Colorado is positioning this case, or does he view this as a free speech religious liberty case, which is, of course, how the challengers, the cake artist, is positioning this case? Or another way to look at this, do you look at this more in the vein of Obergefell and anti-discrimination cases, in which Kennedy was the deciding vote in that 5-4 decision, or do you view this as more like a Hobby Lobby, even though that was a statutory case really invoking, that was the case about whether employers have to comply with the contraceptive mandate, Justice Kennedy casting the deciding vote in a 5-4 decision saying no, they don't, and so based on their religious beliefs. And so I think this is, again, all eyes on Justice Kennedy and really what framing of the case he chooses to view this as.
Paul, let's talk about the Arab Bank case.
Sure, and in the spirit of disclaimers, I'm representing the bank in this case. There you go. So this is, though, for students of kind of the Constitution and the framing era, this is a great case because this actually involves the scope of a law that was included in the first Judiciary Act of 1789. The great thing is it was tucked into the first Judiciary Act of 1789, applied twice in like the first 10 years of the Republic, and then basically forgotten about for about 170 years. And then this, seemingly obscure 33-word provision was rediscovered by some clever plaintiffs' lawyers who brought suit. So the provision, which is permanently codified in the jurisdictional provisions of the U.S. Code, reads in full: the district courts shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the United States. Now, the original purpose for this is actually reasonably clear, and I don't think is that debated by people who have looked at this, which is there was a concern that you could have a situation where somebody could, for example, beat up an ambassador, and then if there wasn't a way to get legal redress in the United States against the person who perpetrated this assault on a diplomat, that could spin into a sort of, diplomatic kerfluffle, which, if things went the wrong way, could end up with an act of war being declared and the like. So it was designed to provide this sort of outlet for potential tensions involving kind of unique situations involving alien plaintiffs and the law of nations. And that's why you have this kind of otherwise kind of weird provision that provides jurisdiction for claims only brought by non-citizens, only brought for tort only, and focused exclusively on treaties and the law of nations. So you can kind of see why, after the first decade of occasionally beating up an ambassador, this didn't get invoked a lot. But it got rediscovered when some plaintiffs decided that they could litigate disputes really arising outside of the United States predominantly, involving alleged violations by foreign governments of the law of nations. And the first case, Phil Artiga, got brought in the Second Circuit. It was brought against a former official of the Paraguayan government who was actually physically located in the United States, so they could jump over all the problems with personal jurisdiction and the like. They sued him, and their theory was that he either perpetrated or aided and abetted violations of the law of nations. So that started really revived this statute that had literally gone unnoticed for almost 2 centuries. And where it really took off is when some plaintiffs figured, let's stop suing sort of former, foreign government officials who've relocated to the United States. Let's sue large corporations. A lot of them located in the United States, sometimes not, but let's sue large corporations, largely on the theory that they've aided and abetted the law of nation violations of other governments elsewhere in the world. And that became, a much more attractive prospect because, there's a lot more money to be made in suing corporations than suing relocated foreign government officials. And so the court was kind of forced, because this really did take off, particularly in the Second and the Ninth Circuit. The court was forced to take a look at this statute for the first time, really, something like 15 years ago in a case called Sosa. And the federal government argued very passionately in that case, as did the defendant, that this provision is just a jurisdictional provision. It doesn't provide a cause of action, and except for those rare circumstances like the Torture Victim Protection Act, where Congress passes a statutory cause of action, this is just a jurisdictional provision. The court did one of those things that courts sometimes do, which is it essentially accepted every argument that the government made for why there should be no causes of action, and accepted them and said, now that's why there should be very rarely causes of action. But it did keep itself in the business of potentially creating what amounts to sort of a federal common law of causes of action for the violation of the laws of nation. In the memorable words of Justice Souter, who wrote the opinion for the court, said, the parties ask us to shut the door to these claims. We keep the door ajar, subject to vigilant doorkeeping. One can't complain about that too much, since it's kept a lot of appellate lawyers in business over the years since, because it's sort of an invitation to say you can still bring these claims, but they'll very rarely be successful and the like. Couple of years ago, there was a case in which the Second Circuit had read that decision and said that, based on a particular footnote 20 in the Sosa decision, that it didn't think that you could bring a law of nations violation claim against a corporate defendant, because most of the prohibitions of the law of nations apply only to nations. A few of them apply to individuals, but almost none of the law of nations prohibitions apply to artificial entities like corporations. The Supreme Court granted review, and after hearing argument on that question, decided that it wanted to hear argument on a different question, which was the extent to which the Alien Tort Statute applies extraterritorially, and having heard argument in that question, strictly limited the extraterritorial scope of the statute and left that question unresolved. This case involves the Second Circuit essentially relying on the same logic as it did back in the day to say that there's no corporate liability. It's a particularly interesting, again, a little bit of inside baseball here, but what makes it kind of interesting is the defendants that I represent were also saying, look, this is an extraterritorial application of this, and we have about 3 other defenses to why this is not a proper action in these particular circumstances. And the Second Circuit panel basically wrote an opinion that says, well, we have this circuit law that says the corporations can't be defendants. We think that's probably wrong. But we're going to apply it because it's circuit law, and we're going to consciously not kind of decide any other issue in the case, essentially almost like daring the Supreme Court to take the case. It worked, and the court took the case, and so it's set to decide this this issue of whether corporations can be liable under this statute. And the defendants have also raised other arguments as to why they win, but the court may feel like it really needs to definitively resolve this question of corporate liability, having now had the case up there the second time and having seen the Second Circuit kind of double down on this particular theory. At first blush, it may seem odd that individuals can be liable and corporations can't, but I do think if you go back to the idea that the core of this cause of action is based on the law of nations and treaties, it starts to make a lot more sense because, as I alluded to, you have law of nations and international treaties generally put obligations on countries, in some cases, individuals, and almost never on artificial entities. So that's the nature of the argument.
Pratik, why don't we wrap up with the Carpenter case?
Sure. I'm pleased to say that I have no disclaimers in this case. I've not filed a brief for anyone. This case once again raises the issue of how to apply the Fourth Amendment when you have new technology. And here the technology is cell phone site data. So a bit of technical background for those not well versed. Every time you make or receive a call on your cell phone or send or receive a text or even certain apps running in the background of your call, it's pinging back and forth with the cell phone tower. And when it pings back and forth with the cell phone tower, it's creating a record of your location. If you're in a highly, densely populated area, urban area with lots of cell phone towers, a pretty precise location. If you're in a rural area, maybe not so precise. But it's creating a record every time this cell phone is interacting with the tower, which may be hundreds, thousands of times a day. The Stored Communications Act is a federal law that allows the FBI, federal law enforcement, to obtain a court order to require a cell phone provider to turn over all of that cell tower data. And it can require, the court can issue that without a warrant and without the probable cause standard that normally accompanies a Fourth Amendment warrant. It's a much lower standard, reasonable relevancy to a federal investigation, or words to that effect. The criminal defendant in this case, who's the petitioner here, was, ironically enough, involved in some cell phone, a string of cell phone thefts. And so the FBI invokes this act, it gets a court order, and has the cell phone provider turn over all the cell phone tower data for a period of 127 days. And they're essentially able to map the movements of this guy for that period, and based on that, come up with a pretty strong case, and that's the basis of his conviction. He then raises a Fourth Amendment challenge based on that conviction. The Court of Appeals, joining every other Court of Appeals that's opined on this issue, rejects the Fourth Amendment claim. And the Court of Appeals relies on this line of Supreme Court precedents from a while ago that basically stand, people call it the third party doctrine, which basically says, look, you don't have any reasonable expectation of privacy in your information once you've turned it over to a third party. And reasonable expectation of privacy is really the test for triggering whether you have a search within the meaning of the Fourth Amendment. If you don't have a reasonable expectation of privacy of the information, you can't have a search within the meaning of the Fourth Amendment. Now, the cases in which the Supreme Court articulated what other courts have dubbed the third-party doctrine involved very different circumstances than cell phones in the modern era, which are constantly communicating with cell phone towers, whether you know it or not. One of those cases is Smith v. Maryland, and although that involved phones, it involved a more conventional log of phone numbers that someone had dialed. And then the other case is United States v. Miller, which involved certain bank records that you had turned over to your bank. And based on those cases, the courts of appeals have, as I said, unanimously held that because this information was turned over to the cell phone provider by virtue of having signed your cell phone, activated your cell phone, that this third-party doctrine precluded a Fourth Amendment claim. Now, despite the lack of a split, the Supreme Court granted cert, which is probably not a great sign for the government. Another bad sign for the government is the Supreme Court has taken up a couple cases in the last few years dealing with the application of the Fourth Amendment to new technology. One of those cases was the Riley case that dealt with applying the search incident to arrest rule to cell phones. So that is normally when you get arrested, if you have a wallet or cigarette box or whatever on you, the police are free to search that. When they arrest you, it's an exception to the Fourth Amendment warrant requirement. But the Supreme Court said, that doctrine really can't apply to a cell phone, especially a smartphone in today's era, where just because you have that on you, police can't go and delve inside that phone and find all the data inside of it. That is just a different order of magnitude when it comes to invasion of privacy. And therefore, the court unanimously held that there's Fourth Amendment protection for that sort of search. Then there was the United States v. Jones case that dealt with GPS tracking on a vehicle. And there again, the Supreme Court was unanimous in saying, well, yes, it's true, normally the movements of a vehicle are public. You wouldn't have that interest in privacy. When it comes to GPS monitoring, that's of a different order. And now there is a Fourth Amendment interest. Now, the court was split, although it was unanimous in the outcome that Fourth Amendment protections apply. It was split on the rationale. Justice Scalia wrote for 5 justices of the court and really applied a rationale that harkens back to the 18th century and saying, look, when the government applies or attaches a GPS device, it's really committing a trespass. And if you commit a trespass, that triggers the Fourth Amendment framework. And the analogy that Justice Scalia used to describe that is, you could imagine back in the days of horse and cart transport, if you had a constable who concealed himself in the target's coach. So there you would think, okay, well that you can't do that. That's a Fourth Amendment violation. It says, look, attaching a GPS device is kind of like that. It's like a constable secreting himself in a person's coach. Justice Alito, for 4 justices of the court, says, well, that doesn't really make a whole lot of sense to me. GPS monitoring is just different when it borders on this long-term sort of thing. It's just a different sort of technology with a whole lot more implications for privacy. And trying to find an analogy to the 18th century really doesn't work for me, he says. And in one of my favorite lines from an opinion, he says, for Justice Scalia's analogy to work, you would have either required a gigantic coach, a tiny constable, or both. And so he says, look, let's just take this for the fact that long-term GPS monitoring is an invasion of a different sort. Petitioner now invokes, of course, both of these lines of cases and saying, look, when you have this cell phone site data, that is also an invasion of privacy of a different magnitude in light of the new technology. And so it distinguishes these prior third-party doctrine cases, which were in a very different context and that really can't control in the circumstance that you have here, where cell phones are ubiquitous today. They're sending these signals without any sort of voluntary, or most people don't even know it's happening, and yet you're creating these records. That doctrine just doesn't make sense. The government is trying to defend the doctrine, as you might expect, and says, look, the doctrine is still alive and well today, and it tries to distinguish the Jones case by saying you don't have anything akin to a physical trespass in this case, and therefore the government has an interest in getting these communications. They're not seeking the content of the communications. They're simply trying to get the location information, and there's no reasonable expectation of privacy in that information there. Again, obviously this will have huge implications for law enforcement and privacy. You can imagine applications, website history, email history, all of these sorts of things being implicated in the case. Now, the justices themselves, I expect, while I don't think it's going to be a good result for the government, the court does tend to tread lightly in areas like this where it's implicating new technology. The justices are not necessarily fully confident in their comprehension of the knowledge, and they certainly don't want to issue a ruling that has unintended effects. And I think, as Justice Kagan has said, and this is her words, not mine, the justices are not necessarily the most technologically sophisticated people. And by way of example, she stated, the court really hasn't gotten into email yet. And so dealing with this sort of technology raises issues there. But I think the Fourth Amendment implications are pretty clear here. And you could have, I think, maybe another broad decision for the government. The other interesting thing will be to watch here is Justice Gorsuch, his first big Fourth Amendment case, to see if he has any sort of views that may differ from his predecessor in this area. And so I think that's another thing to keep an eye on.
So we'll open it up for a couple questions from the audience, but I wanted to ask one for both of you first. Are there any issues on the horizon that you think the justices are likely to take up, perhaps later this term, capital punishment, whether Title VII employment discrimination extends to sexual orientation? Maybe the court's going to take a case looking at its deference doctrines. if either of you'd like to comment.
Happy to start. I mean, the Title VII case, that cert petition, there was a cert petition, for those of you who haven't been following it, that was just filed earlier this month, I think based on a decision out of the 11th Circuit, in which the Court of Appeals held Title VII as the piece of legislation that bars certain forms of employment discrimination. And there, the person was alleging that he was discriminated on the basis of sexual orientation, and the Court of Appeals said that Title VII does not protect against discrimination based on sexual orientation. It protects discrimination based on sex, and that's different from sexual orientation. Now, that decision created a conflict with the 7th Circuit, which last year held that, in fact, Title VII does protect against sexual orientation-based discrimination. I'm inclined to think that the court will probably pass on the case this time around. I mean, who knows? But there's a Second Circuit case that's en banc right now, in which the Second Circuit is addressing the same issue. I suspect the court may want to let this percolate a little bit before it jumps in and see this issue vetted a little bit more. And of course, they already have the Masterpiece case this term, and so I wouldn't be surprised if the court decided to wait a little bit longer on the Title VII issue, but I do think it will be in front of the court at some point because it's too big of an issue for it to not weigh in.
Yeah, and I would just, you mentioned the sort of, deference to administrative action and the like, and, certainly, with Justice Gorsuch, sort of having written on the topic of sort of Chevron deference, having the court sort of, itself, Justice Scalia and others kind of raised the question about whether, so-called seminal rock or our deference, which is the extent to which an agency gets deference to its interpretation of its own statutes. It's hard for me to believe that, that with those signals being there, that you're not going to have lots of litigants trying to get the court's attention on those issues. And it strikes me that there's a good chance that somebody will. It may be that the seminal rock hour deference is the lower hanging fruit. And obviously, anytime these cases can come up one of two ways. It can come up as sort of, this is a case about hour deference, or you can have a case where, the court just has to interpret some statute where there's an administrative proceeding at issue, and in those cases, the issue of deference can sort of come up. And, I don't know how this will play out. Could be Justice Gorsuch writes a major concurrence in some otherwise not, obviously a Chevron case that is kind of the vehicle then for somebody to really tee up exactly the issue he wants to hear. But I would be surprised if, sometime either this term or next term, we don't have a case that pretty squarely puts a deference issue in front of the court.
All right, are there any questions? Over here. Please wait for the microphone and identify yourself.
It's Jess Braven of the Wall Street Journal. A question for Paul and Pradeep too, if you want to weigh in. What's the positive argument in favor of partisan gerrymandering? I mean, is there an argument that it is a beneficial and admirable kind of bedrock of American democracy, or is it just a necessary evil that is impossible to rectify?
Well, I mean, the burden on, the government in a case is not to explain why, what it's doing is, or what it's alleged to have done is, sort of great. It's really, the challenger's burden to show that what the government's doing is violate some principle of the Constitution. So, in that sense, and I don't mean to sidestep the question, and I'll try to give you something more of an answer, but that, in terms of a policy debate about whether partisan gerrymandering is a good thing or a bad thing, that's more relevant. But in terms of, exactly what makes the practice of a legislature that tries to design some districts for partisan advantage, what makes that, unconstitutional won't necessarily turn on sort of what's on the other side of the ledger. I think, the argument is, is less really that this is, partisan gerrymandering is an affirmative good, but more that it's just implicit in the notion of textually delegating the authority to redistricting to a legislature. And so, I mean, it would be a little weird to have something where you textually designated a particular function to casinos, but then be particularly concerned if there's gambling going on. And I think, the framers pretty clearly did textually delegate redistricting to state legislatures. And so to say that, at least for about 180 years, they've been partisan state legislatures, to say that sort of, something that is inevitable in those legislatures discharging their function becomes unconstitutional if there's just too much of it. I think that's a hard thing to explain exactly where you cross the constitutional line. And that's why, I do think it's as interesting to try to figure out less like what's the test for this, but also, all right, even if we can identify it, what exactly about it precisely violates the Constitution and when? Because unless you're going to take legislatures out of the process entirely, it's, they are going to, at the margin, redistrict with sort of partisan goals in mind. And then the other thing just to kind of keep in the back of your mind, which I think also makes this just an interesting case to think about, is like, surely it is true that a lot of non-districting legislation has a partisan motivation. And, that's why, certain, you have right-to-work states, you have, pro-union states, you have tax cuts or tax raises. A lot of that it involves, at least in part, a calculation about partisan advantage. And I don't think people are generally ready to say that that becomes a constitutional violation. So then the argument becomes, is there something different about redistricting? And there certainly are arguments about that. But some of the arguments about what makes redistricting different and what makes partisan action in this context uniquely problematic, are good political theory arguments and might lead well to a Republican form of government clause challenge if the Supreme Court hadn't made so darn clear those are non-justiciable. But they don't perfectly map up to an equal protection theory or a First Amendment theory. So I think those are some of the kind of hard questions that both sides are going to have in trying to figure out how does this test map up to the constitutional prohibition.
Anything to add?
No, I mean, I don't represent anyone, so I'll give you my answer. I mean, in anything I've read, I've never seen a policy defense of partisan gerrymandering. I think it's more of the necessary evil that you say. I mean, it's kind of, as Paul said, it is somewhat hardwired into the process. But I think the reason why it draws more concern than some of the other sort of partisan enactments is just the sense that it goes to the core of how you elect people, and can you rig the system in a way that skews the fair elections and those sort of concerns. So I haven't really seen a policy defense of partisan gerrymandering. Really, I think the argument from a legal perspective is it so bad that you can find it unconstitutional under some theory that doesn't necessarily map really well onto the Equal Protection Clause or First Amendment.
Well, I see we've gone a little bit over our time, but before we close, I want to invite you all to join us next week on Thursday for the next event in this series, which will be hosted by my colleague Hans von Spakovsky, and it's going to be a debate on President Trump's travel order. So thank you all for coming today, and please join me in thanking our panelists.